Good afternoon, people. Good afternoon, everybody. A very good afternoon to all of you. Just let me know quickly if I'm properly visible and audible to all of you so that we can start our today's session. Let me know in the chat box if I'm properly visible and audible. I'm really sorry there was some technical issue due to which it delayed. But now it is okay, so we can resume our today's class. So share the link of the class to all your friends so that everybody can join. Share the link of this class to all the groups. I'm sharing the link of the class in all the groups. Just wait for 2 minutes so that everybody can join and settle, and finally we can start our today's session. Great. So a lot of people have joined and finally we are good to start with our today's session. Okay, I'm properly audible. Great. Everybody is saying okay. Good afternoon, Vaishnavi. Good afternoon, Trisha. Good afternoon, Sonia. Good afternoon, everybody. Palak, Sachin, Ayush, everybody. Good afternoon. A very good afternoon to all of you. So yesterday we started with our chapter of MOA and AOA. So today we'll continue with MOA and AOA. After that, we'll do one of the most important chapter of your SBEC, which is alteration of MOA and AOA. Right? So great. So yesterday we studied all about the MOA and AOA. What is MOA? What is AOA? What is the difference between MOA and AOA? And what are the important clauses of the MOA? Till 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 that we were done yesterday. So today we have to start with the doctrines. Doctrines, there must be one question, at least one question must be there in your SBC paper from your doctrine. So basically there are four doctrines in this chapter: doctrines of ultravirus, doctrines of constructive notice, doctrine of indoor management, and doctrine of alter ego. So there are four doctrines in this chapter. We'll study each doctrine one by one, and after that this chapter will be done, and then we can start with your alteration of MOA and AOA. So just let me know give me a quick thumbs up in the chat box if we are good to start with our today's lecture. Today's flow will be MOA AOA and then alteration of MOA AOA. Give me a quick thumbs up in the chat box, also thumbs up to the video so that we can start our today's lecture. Okay, great. Everybody is good to start. Okay, so finally, the first topic of today is doctrine of ultravirus. What do you mean by doctrine of ultravirus? Ultravirus means something which is not within the power of the company. And you know, yesterday we studied that the MOA defines the power of the company. And if a company does any act which is beyond the power of MOA, then that is said to be ultravirus and thus void. So basically, this is the doctrine of ultravirus, which says that company should work within its power. If company does any activity which is not within its power, which is not within the power given by the MOA, then it will be ultravirus and null and void. It will not have any legal effect. And this doctrine of ultravirus was introduced to protect the shareholders, to protect the creditors of the company, so that the company does not does any act to defraud shareholders, to defraud creditors. And you know what? If company does any act which is not allowed by the MOA, then such act will be totally void ab initio, totally null and void. Even the shareholders cannot rectify that act. Even the shareholders, by giving all the approval, even if all the shareholders give approval to that act, then also they cannot ratify that act, then also they cannot make that act valid, which means that the anything which is done beyond the power of MOA, then that is ultra-virus. Let's say if company is not allowed to borrow money to raise loan, if company is not allowed in its MOA to raise loan, then company cannot raise loan. So company cannot do any activity which is not permitted by the MOA, and if company does any such activity, that will be ultra virus and void, and it cannot be ratified even by all members, even with the consent of all the members. There is one very important case of the doctrine of ultra virus, which is Ashbury Railway Carriage and Iron Company Limited and Riche. You can see here this case law, Ashbury Railway Carriage and Iron Company Limited versus Riche. So if question comes from doctrine of ultra virus, it will be good if you will quote this case. So this is an important case. I'm not asking you to remember all the case, but if you can remember this case, then you can quote it in the question of doctrine of ultra virus, Ashbury Railway Carriage and Iron Company Limited versus Riche. So basically in this case, company entered into financing activity. This railway carriage company entered into agreement to finance. There's a firm of Riche, to finance the firm of Riche, but that was not allowed by the MOA. So later on court says that no, company cannot give loan because it is not allowed by MOA, so it is ultra virus. So this is the doctrine of ultra virus. I hope you all understood it properly. Revised. This is the concept of doctrine of ultra virus, which says that if any activity is done beyond the power of MOA, that will be null and void. And it's good if you remember this case, Ashbury Railway Carriage Iron Company Limited versus Riche. It's not necessary to write what happened in this case, but it's okay even if you just quote the name of the case. Right, we can move forward. There's one small point, that whether the ultra virus borrowings is valid. The answer is no. Ultra virus borrowings means, you know what, even if a company want to take loan, that should be authorized by the MOA. That should be specifically allowed in the MOA that yes, a company can take loan. And if a company is not allowed to take any loan, and even after that company borrows any money, then it will be said to be ultra virus borrowing, which means this borrowing is not within the power of company, and this will be void. And company will not be liable to repay that money. But there is one exception to it. The exception is if the ultra virus borrowing is used to discharge the lawful expense, then the lender may recover the amount, which means that if you are taking ultra virus borrowing, but you have applied that ultra virus borrowing, you have used that ultra virus money for discharging some lawful expenses, which means the loan was illegal, the loan was void, but you use that loan money to give some valid money, to give some legal money, to make some legal expenses. In that case, the lender can recover the money. So this is one of the exception. I hope you are getting this point. The very important concept of this doctrine of ultra virus is implied powers. This is important. Implied power means, let's say Yashas Academy, we are empowered in our memorandum to provide education. So we have power to provide education, and in order to provide education, to make agreement with teachers. So this is implied power because we can provide education. For providing education, agreement with teachers, hiring teachers is important. So this is something which is implied power. So in order to carry out the main object, if you have to exercise certain other powers which is incidental or very implied, which is very obvious that you have to do this power, you have to exercise this power in order to attain the main object, then that is known as implied power. Implied, another name is incidental power, or we can say inferred power. And these implied powers are not required to be expressly mentioned in the MOA. But you know what? There are certain exceptions to it. This is important. In the recent exam, this question was asked the powers which are not implied, which means that there are certain powers which cannot be implied, which cannot be assumed. You have to expressly write this power in the MOA. If you want to exercise these powers, then you have to expressly write these powers in the MOA. So these powers are not implied, which means if you want to exercise all this power, you have to expressly mention in this MOA. Example, madam, acquiring any other business. You want to take over any business. You want to take over, like Facebook took over Instagram. So if you want to acquire any business, if you want to do agreement to carry on business in partnership, let's say Ishika Agrawal and Naman Jain entered into partnership to provide education. So this will be like, if two companies X Limited, Y Limited enter into partnership, then it should be expressly permitted in the memorandum. Example, purchasing share of any other company with the similar object. Similar object, let's say Infosys and Wipro, and Infosys want to purchase the shares of Wipro. So it's like they are into similar object and purchasing shares. Taking shares of another company where the investment authorized the doing indirectly, that will not be intravirus if done directly, which means that if the company is prohibited from investing into any company, so you cannot indirectly invest in that company. Let's say the company is prohibited for investing in real estate, so you cannot invest in any company which is engaged in real estate. It will be like indirect prohibition unless and until expressly it is mentioned in the MOA. So for exercising these power, there must be express permission in the MOA. Example, promoting someone financially, giving someone loan, helping someone financially. Example, selling off your business. If you want to sell off your business, it is not an implied power. You have to expressly write this in the MOA. To provide funds for political party, Modi ji, you want to give donation to Modi ji. You want to give donation or charities. You want to give some, the company want to give some charity to the NGOs and all. The company want to give guarantee. So for all giving all this activity, there must be express power. For doing all this activity, there must be express power in the memorandum. They are not implied. They are not implied. They are not assumed. There should be express power. Then only you can do this, or else you cannot. Or else you cannot. What are the effects of ultra-virus transaction? Very important. Since I already told you that ultra-virus transactions are void from the very beginning, which means void ab initio. So ultra-virus transactions are void ab initio, which means void from the very beginning. Apart from this, there are two other effects, or let's say consequence of ultra-virus transaction. What are the consequence of ultra-virus transaction? Number one, it is void ab initio. Number two, court can impose stay order in you. Let's say the company is not allowed to make investment. Let's say the company is not allowed to make investment, and in case company is making investment, court will impose stay order. Court will impose stay order that you were not allowed to make investment. Now you can't do so. Now you can't do so. Court will provide injunction, stay order. Lastly, directors will be held personally liable. Let's say company was not allowed to put money in, to invest money somewhere, but directors knowingly invested 2 crore rupees of the company. Now for the loss of that 2 crore, director will be held personally liable. So the shareholders can ask directors that because of the you company suffered loss of 2 crore, now you have to bear this 2 crore loss, and you have to reimburse this money to the company. So for the ultra virus act, if there is any loss to the company, the directors can be held personally liable to repay that money. So very clear, very clear. What are the effects of ultra-virus transaction? You can say all the three effects even without seeing, even with closed eyes. Number one, void ab initio. Number two, void ab initio. Number two, stay order injunction. Number three, directors will be held personally liable. I hope this point is crystal clear, and this remaining you can write it on your own. Right. The next very important topic is doctrine of constructive notice. The next very important topic is doctrines of constructive notice. And you know what? Doctrine of constructive notice and the doctrine of indoor management are just opposite of each other. They are just opposite of each other. This protects company and this protects outsiders. Constructive notice protects company against outsider, and indoor management protects outsider against company. So what is the basic difference? The basic difference is that constructive notice means deemed notice, because the two most important documents of the company, which are MOA and AOA, these two documents are registered with ROC and available in public document. You can inspect MOA and AOA of any company. It is a public document. That is why once the MOA AOA get registered with ROC, it is deemed that yes, we have given notice to whole world. Everybody knows about our MOA and AOA. Everybody who's dealing with the company has read and understood the MOA and AOA of the company. So it's like a deemed notice. It's deemed notice. Now company is not liable to expressly tell about its MOA and AOA to any third party who's dealing with the company, to any person who's dealing with the company. So I hope you are getting this point. What do you mean by doctrine of constructive notice? Doctrine of constructive notice means that everybody who's doing transaction with the company, who's dealing with the company, is deemed to have proper knowledge and understanding of the public documents, that is MOA and AOA of the company. So here it is said that let's say the company, this is the company, and company was not allowed to borrow money in MOA, and here company goes to Mr. A for loan. Company goes to Mr. A for taking loan. So here if Mr. A gave loan without reading the MOA, now Mr. A cannot claim any protection. Why? Because it's the duty of Mr. A to read the MOA and AOA of the company before dealing with this company, before doing transaction with this company. So this company can assume that if you are transacting with the company, you have the knowledge of the MOA and AOA. So that is why this is the constructive notice. This protects company against outsiders. So company can take a protection that I thought you have already read the MOA. I thought you already have the knowledge of MOA. So this protects company against outsider. And the famous case of doctrine of constructive notice is this Kotla Venkaswamy versus Ramamurul. Ramamurul. And what do you mean by doctrine of indoor management? Doctrine of indoor management is just opposite of the constructive notice. Just like doctrine of constructive notice says that the outsiders are deemed to have the notice of the MOA, they cannot inquire into the detailed internal matters of the company. So outsiders, while dealing with the company, they can assume that the company has followed the internal procedures and provisions. They don't have any duty to look into the internal matters of the company. They don't have any duty to check whether the company has followed its internal procedures or not. So one famous example for this is, the famous case for this is Royal British Bank versus Turquoise, and that is why this doctrine of indoor management is also known as Turquoise rule. This doctrine of indoor management is also known as Turquoise rule because of this case, Royal British Bank versus Turquoise. This case of doctrine of indoor management was first established in the case of Royal British Bank versus Turquoise. And let's take an example. Let's say that this company has in its article, this company has written that in order to issue shares, we will pass special resolution. So this company has written that whenever we will issue shares, we have to pass special resolution. Now this person is purchasing share of the company. Is this person liable to check whether the company actually passed SR or not? No. Although it's his duty to read the MOA and AOA. So he just have the duty to read and understand MOA AOA. He is not liable to make the detailed investigation into the internal affairs of the company, that whether the company has followed the internal procedures or not. So he can assume that yeah, company must have passed SR. So it's not liable to check whether the company actually passed SR or not. So this is the famous doctrine of constructive notice and doctrine of indoor Management, Doctrine of Constructive Notice, and Doctrine of Indoor Management. So we are done with this concept that MOA, AOA, what does Doctrine of Constructive Notice says that MOA and AOA are the public documents. That is why it is a deemed notice, implied notice to the public, and whosoever is dealing with the company, we can assume that they have read this document and understood this document properly. So this is the famous concept of Doctrine of Constructive Notice. Doctrine of Indoor Management is also done. It was discussed in the case of Royal British Bank versus Turquoise. This is a very good line, that outsiders are bound to know the external position of the company. That outsiders are bound to know about the MOA, the structure of the company, but they are not bound to know the indoor management. They are not bound to know the indoor management. With this, we are done with three important doctrines of the day: Doctrines of Ultravirus, Doctrine of Constructive Notice, and Doctrine of Indoor Management. Give me a thumbs up in the chat box if you're clear till here. Great. Clear. Great. Ankush Pink says clear. Great. Okay. So now you know what? There's one section in the Companies Act 2013, section 176. Section 176. You must have studied this section in the company law paper as well. And this section 176 says that if any appointment of director is invalid, but you don't know, and later on you got to know that the appointment of director is invalid, then all the acts done by that director will be valid before we got to know, which means that let's say on this date we appointed a director on, let's say 6th, today's date 6th June 2022, we appointed a director, but later on, let's say on 25th August, आप लोगों का रिजल्ट डेट 25th August 2022, we got to know that the appointment was invalid. So all the acts done by the director during this period, between the date of appointment and the date when we got to know that the 176, which says that it means later on it is noticed that the appointment of director is invalid, then the action taken by the director before such notice will be valid, but after such notice will be invalid. So even if after knowing that this director appointment is invalid, even after that in this period, now if you will do any act, then this act will be invalid. I hope this point is crystal clear to all of you. Very important, exceptions of Doctrine of Indoor Management. Exceptions of Doctrine of Indoor Management. Doctrine of Indoor Management protects outsider against the company. Doctrine of Indoor Management protects outsider. It says that the outsider are not liable to make the detailed investigation into the affairs of the company, and they can assume that the company has followed its internal procedures, but there are certain exceptions to this Doctrine of Indo Management. Number one, when the outsider had no knowledge of irregularity. Am I properly visible and audible? Am I properly visible and audible? Is it okay now? Is the video okay now? Is the video okay now? Is it okay now? Yes, yes, I will explain again. Is it fine now? Okay, great. Don't worry, I'll explain again. So now coming to the next topic, that is exception to Doctrine of Indo-Management. So Doctrine of Indo-Management says that it protects outsider, and it says that the outsiders can assume that the companies had followed the internal procedure. They are not liable to make the detailed investigation into the affairs of the company, and they can assume that the company has followed the internal procedure. But there are certain exceptions to the doctrine of indoor management, where there are certain exceptions to the doctrine of indoor management where they will not be given protection. There are 4 cases in which the outsiders will not be given protection. Great. So there are 4 situations of the exceptions where outsiders are given protection, where outsiders can't take the protection of doctrine of indoor management. So number one, when the outsider don't have the knowledge of irregularity, sorry, when the outsider had the knowledge of irregularity, means ki they know that the SR was not passed, still they did not took any action. They did not took any action. It's like you have taken fire insurance and you are seeing the house burning, still you are not doing anything, you are enjoying the burning house. Now you will not get any protection. Now you will not get any protection. Why didn't you took step to stop the fire? So it's like if you had the knowledge of irregularity, then if you had the knowledge of irregularity, then why didn't you took action? Then you cannot take the protection of doctrine of indoor management. Number two, you not even consulted the MOA and AOA. If you didn't even consulted the MOA AOA, if you had no knowledge of the MOA AOA, then you can't take the protection of indoor management. Doctrine of indoor management protects only those who are not negligent, who have at least read the public documents of the company, who have at least read the MOA of the company. So if you have no knowledge of MOA, then doctrine of indoor management cannot protect you. Number three, forgery or void or illegal transactions. Nothing can validate forgery. Nothing can validate forgery. Forgery means if anybody's signature is forged. Forged means not original signature, fuzzy signature. Somebody copied your signature. So nothing can validate forgery. If any document is forged, then you cannot say no, 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 no. We will consider it. You cannot take the protection of indoor management. Let's say the company issued document bills of exchange, and in that the sign was forged. The company issued any document in which the sign was forged. Now the outsider cannot take the protection of indoor management. Why? That document is forged, bro. That document sign is not valid. That sign is fake. Fake sign. That document can never be valid. So nothing can validate forgery or illegal transactions. Number last, negligence. If you did negligence, let's say आपको शक हो गया था, somehow you noticed that yes, something is wrong, this company is not having power to do so. However, you were negligent, you didn't inquired. So if you have doubt that company does not have power to do so, to do this activity is not looking proper, this is not properly followed, and still you were negligent, you didn't made investigation, then you cannot take the protection of indoor management. So the doctrine of indoor management protects outsiders, that they can assume that the companies have followed the internal procedure. But there are 4 exceptions where the outsiders are not given protection. Number one, if they already had the knowledge of irregularity. Number two, if they didn't even consulted the MOA. Number three, forgery, void or illegal transactions. Number four, negligence. If there is a negligence of that person who is dealing with the company, then he cannot claim the protection of doctrine of indoor management. I hope this point is crystal clear to all of you. With this, we are done with the exception of MOA and AOA. Exception of MOA, AOA. After that, the next topic is interpretation of MOA and AOA. Interpretation of MOA, AOA, which is very easy. Sometimes there might be confusion or irregularity in interpreting the MOA, AOA. So how will you interpret the MOA? you should always read them together. Like always, MOA and AOA supplement each other. So you should always interpret and read them together in case there is any ambiguity. How will you read the article? You should read article, you should interpret article in such a way that it improves the business efficiency. So article should be interpreted in a way that it improves the business efficiency or business efficacy. How should the memorandum be interpreted? Memorandum be interpreted according to the principles of interpretation of legal documents, because MOA is a legal document, and the principles which you apply, basically all the principles of interpretation and jurisprudence which you study in JIGL. So you should apply those principles of interpretation in order to interpret the MOA. And how to interpret MOA? MOA and AOA should also be read and interpreted together to supplement each other in case of ambiguity. So this is the small point of the interpretation of MOA and AOA. The last doctrine of this chapter is Doctrine of Alter Ego. Alter Ego. Ego means not ego. Ego means here second self. It's like I gave a power of attorney to, let's say, Ramu to do all the act on behalf of me. So I can say that Ramu is alter ego, second self, which means perfect substitute. Perfect substitute. And you know that company is an artificial person. In case of company, who does all the act on behalf of company? Directors, officers, shareholders. So we can say that they are the second company. So we can say that they are the perfect substitute of the company. And that is where they can do the misuse of the company. They can use the name of the company for the fraudulent purpose. So this doctrine of alter ego says that if any shareholder, director or officer of the company use the name of the company to do fraud, to do unfair or fraudulent transaction, in such a case, company will apply the doctrine of alter ego and will hold this shareholders, director, officer as the perfect substitute of the company, as the second company, and for that default of in the name of company, they will be held personally liable. This is similar to the concept of lifting of corporate will. So here one very simple word, it is said that doctrine of alter ego means perfect substitute or second self. So if the shareholder, director, officer use the name of the company for fraud, then the shareholder, director will be held personally liable. So this is the very small doctrine of alter ego. With this we are done with the four important doctrine of this chapter, which is doctrine of ultravirus, doctrine of constructive notice, doctrine of Indo-Management, and doctrine of alter ego. You might find one question in your paper from this four doctrine. Okay, so we are done with the doctrine of alter ego. The next is difference between MOA and AOA. We have already done through this differentiation. We have already done the difference between the MOA and AOA. Now, one of the last topic is the effect of MOA and AOA. One of the last topic of this chapter is effect of MOA and AOA. Okay. Okay, this is given in section 10. Section 10 tells about the effect of MOA and AOA, which says that MOA and AOA binds. Binds means you have to comply, you have to abide by MOA. So MOA binds members to company, company to members, members to members, but company not bound to outsider, company not bound to outsiders. So what are the effect of MOA and AOA? That MOA binds company in such a way that members, there are four effect of MOA. Members are bound to company, company is bound to members, and members are bound to each other. One member is bound to another member, but company is not bound to outsiders. But company is not bound to outsiders. So number one point, member bound to company, which means that you know what, MOA AOA is considered as an agreement, as a contract between members and company. So MOA AOA is the contract between the members and the company. So whatever is written in the MOA, members have to comply with that, member have to abide by that. So if MOA it is written that member cannot sell their shares without the permission of Mr. X. Mr. X is the promoter, let's say. So if that is written in the article, then member have to abide by that. So let's say there was a point written that members cannot sell their shares beyond this price, there was some restriction, so members have to comply with that. So members are bound by the company. Number two, company is also bound to the members, which means that company, if company has done any promise to the members, then company has to follow that. Company cannot do anything which is against the memorandum or which is against the members. So companies also company has to follow the MOA in the interest of members. Company is also bound to members. Lastly, one member is bound to another member. So by MOA and AOA, though it is not an express contract between one member and another member, it is a contract between company and member. So one member is not directly liable to the another member, but they are bound by each other. So let's say one member did fraud with another member, then this member can sue another member. So in case there is a fraud, then one member can sue another member, can file a suit against another member. So this is a point that members are bound inter se, but generally members cannot directly sue the other member. Members have to sue the company and company will sue the other member. So member has to follow the route of the company, but in case there is fraud, then members can directly take action against the other one member can directly sue the another member. So members are bound to each other, though MOA is not an express contract between members, then also members are bound to each other, but company is not bound to outsider. And you know what, here outsider means every person other than member. So even if you are a director and you are not the shareholder, you are the outsider. Solicitors, lawyers, auditors, everybody is outsider. So here outsider means a person who is not the member. So everybody other than member is outsiders and company is not bound to outsiders. So on the basis of article, on the basis of MOAA, company is not bound to directors, company is not bound to auditors. Let's say company has said me, Ishika, you are practicing company secretary now. Company has said me, we will appoint you for like 10 years. We will not remove you till 10 years. In the article, they have written that in their article. So now can they removed me? Can I sue? The answer is no. Why? Because by the virtue of article, company is not bound to outsiders. But there is one exception, that if on the basis of that article another contract is made with the outsider, then that contract will be valid and that can be enforced in the court of law. Outsider can take the protection. So let's say if on the basis of that article company entered into another contract with me, that Ishika, we will appoint you for the 10 years, we will not remove you for the 10 years, then in such a case I can take protection on the basis of that contract. So by virtue of MOA, company is not bound to outsider. And lastly, all the money which members agree to pay to the company by virtue of MOA becomes a debt for the members. So this is the final effect of MOA and AOA, which is given in section 10 of the Companies Act 2013. And you know what? We are done with this chapter, MOA and AOA. See here, you can see the topic. Legal effect of MOA: member bound to company, company bound to member, member inter se, company not bound to outsider. We are done with this. And money payable to the shareholder. We are done with this also. So we are done with our chapter number 4, which is MOA and AOA. Now we are good to start with our chapter number 5, alteration of MOA. We'll try to do it faster, in a fast manner, and we'll try to complete this chapter today, alteration of MOA. Although this is one of the biggest chapter of your part A, since we started half an hour later, so we'll not be able to start the conversion chapter today, but we can do the conversion chapter tomorrow. Today we'll try to cover this chapter number 5, which is alteration of MOA and AOA. Tushar is saying clear. Great. CCM, crystal clear, great. Chapter number 5, Alteration of MOA and AOA. And in this chapter, so many dangerous, lengthy procedures are given. In this chapter, so many dangerous and lengthy procedures are given. But don't worry, we have short notes for that. We have charts for that. So we'll study this chapter from the charts. Great. So when I talk about MOA and AOA, how can you alter MOA and how can you alter AOA? As you remember, there are 6 clauses in the MOA: name clause, situation clause, object clause, liability clause, capital clause, and association clause. Can you alter the name situation? Yes. Object? Yes. Liability? Yes. Capital? Yes. Can you alter the subscription clause? No. So there is one clause in the memorandum which cannot be altered, which is association or subscription clause. Why? Because it's like you can't change your gave birth to a company. Now company cannot change the name of the person who gave birth to a company. Company cannot change the subscriber to the memorandum. Chidiya chug gayi khet. Now cannot be done. You can't change your parents, so that is why company cannot alter the subscription clause. Apart from this, any of this clause can be altered. Now one by one, we will study the procedure. How to alter the name clause, how to alter the situation clause, how to alter the object clause, the liability clause, and the capital clause. And after that, we will be done with alteration of MOA, and after that, we will start alteration of AOA, and then your chapter will complete. So basically, you have to study the process of alteration of MOA and AOA. Alteration means to make changes. If you want to make changes, can your name be changed? Yes, your name can be changed. Your name, can a company change? Initially the ITC name was I.T.C. Now it is ITC. Why? There is a change in name. We deleted these dots. So now its name is ITC Limited. So can a name of the company be changed? Yes, with the approval of MCA, with the approval of basically CRC. Remember, do you remember that I told you company cannot choose any name on its own? Company has to take the approval of the government. Company has to take approval of the CRC to finalize any name, to use any name. So that is why when you are altering the name also, that time also you have to take approval from the government. Now what is the process of altering the name clause? The first clause which can be altered is the alteration of name clause, which is given in section 13, subsection 2 and subsection 3. Basically section 13 talks about alteration of MOA. So first let's talk about the alteration of the name clause and how can it be altered. Alteration of MOA and AOA. Number 1, alteration of name clause, which is given in section 13. Obviously, basically, you have to pass special resolution and you have to take approval of the CRC, ROC CRC by applying through run. Remember in the incorporation chapter, I told you that when you have to apply for the reservation of name of new company, then you apply through Part A of Spice Plus. But if you have to apply for the change of name of existing company, then you apply through Run. Okay, yes ma'am, yes, we remember. So what is the process? First you have to hold the board meeting and pass the board resolution so that you can apply to the ROC. So in order to apply to the CRC for taking approval, you have to pass board resolution for making application. Now you have to make application to the ROC CRC that ROC I want to change my name. Please reserve my this new name. Please approve this new name. So you have to make application to the ROC CRC through Run. Run is a web service, reserve unique name. And then if ROC will find everything okay, if CRC will find everything okay, then CRC will reserve your name and give you a letter, name reservation letter. Then CRC will give you a name reservation letter. Then CRC will give you a name reservation letter which will be valid for basically 60 days. And after that you have to pass special resolution. But whenever you have to pass special resolution, you have to call general meeting, and before calling general meeting, first you have to call board meeting. So now you will convene board meeting and pass board resolution so that you can call general meeting. Now you will issue notice for calling general meeting, and then you will hold the EOGM, that is extraordinary general meeting, and in the EOGM you will pass special resolution finally for the alteration of name clause of the company. And you remember that whenever there is a SR, Fevicol MGT 14, whenever you pass SR, you have to inform to the ROC in the form number MGT 14, in the form number MGT 14 within 30 days. So here you pass a special resolution, now you have to inform to the ROC in the form number MGT 14. Done, madam, done. Now you know what? Whenever a company's name is changed, we have to obtain a fresh certificate of incorporation from the ROC, and in that case we have to apply again to the ROC that ROC, we changed our name, please give a fresh certificate of incorporation, and then you have to file application to the ROC for giving you fresh COI, and you will make that application in the form number INC 24 within 30 days, of passing the special resolution, and you will make that application to ROC, and then ROC will enter the new name of the company in the register and will issue fresh certificate of incorporation, and that fresh certificate of incorporation will be in the form number INC 25, and from that date when the new certificate of incorporation is issued, from that date the new name will be effective. So this is the whole process of name reservation. You don't have to study this 3-pager procedure from the book. You can just read it for just the language, but the whole process is covered in this chart. Great. So now there's one point that if you are changing a public company into private company or a private company into public company, there is just addition or deletion of the word private. So let's say I have a company Edu-Mention Private Limited, but I am converting this company into public company. So I will delete just this private word, and now my company's name will be Edu-Mention Limited. So in this case, I don't need to take the approval of CRC again. I don't need to file run again. So here I don't need to take this name reservation just for the addition or deletion of the word private due to conversion. But if there is any defaulter company, that company is not allowed to change its name. So if there is any company which is defaulted in filing annual return or financial statements, or any company which has failed to repay the deposit or debentures or any interest, then that company will not be allowed to change its name unless and until it made good the default. So if the company now filed all the pending returns and paid all the money, all the deposit money, now after making good the default, after filing this returns and after paying all the money, then you can change your name. So this is the small procedure of alteration of name clause of the company. Alteration of name clause of the company. This is the small procedure of alteration of name clause of the company. The another process is rectification of name, which is given in section 16. You know what do you mean by rectification of name? That sometimes it happens that people copy someone's name. Let's say I form a company name Reliance Education Limited. Let's say I formed a company named Reliance Education Limited. Can I do so? The answer is no. Why? Because Reliance, there is existing company in the name of Reliance. Mukesh Bhaiya can sue me. Mukesh Anna can sue me. So what we have to do in that case, if anybody copies your name, then the Mukesh Ambani, if I copy Reliance name, Mukesh Ambani can cry and go to central government and say that central government, this person copied my name. Please say this person to not to copy my name, not to use my name, to change name, to change its name and not to use the word Reliance. So there's one point of rectification of name in which central government can give order to a company to change its name. And when a central government will give order, if in the opinion of central government it is identical or similar to any existing company, or it is identical or similar to any existing registered trademark. So in two situations central government will give order. If central government is of the opinion himself, or Any application to the central government is made by the registered trademark owner. In that case, if central government is of the opinion that the name of the company is similar, I formed a company Reliance Education Limited. My company's name is similar to Mukku Bhaiya company. Yes. So if the central government is of the opinion that the name is similar or too nearly resemble to another trademark or another company, then central government will order me, hey, change your name, change your company's name. Central government will order the company to change its name, and you have to change your name within 3 months by passing ordinary resolution. Within 3 months you have to comply with the order of central government and change your name by passing ordinary resolution. Please note that usually in order to change the name, we have to pass special resolution. But if the central government is ordering, then we have to just pass OR, ordinary resolution. And after we change our name, we have to inform to the ROC within 15 days, and then ROC will enter the new name and will issue the fresh certificate of incorporation in the form number INC 25. So this is the small procedure of rectification of name. But what if I don't change the name? What if I don't comply with the order of central government? And you know what, here central government power is delegated to RD. So RD can basically order a company to change its name. But what if the company don't comply with the order of RD? In such a case, my a tag will be given to me that I am the defaulter company. In such a case, central government will itself change the name of the company. And you know what it will change? It will change the name of the company to this ORDNC plus year of passing the direction plus serial number plus existing sin. So what they will give the name of the company? The name of the company will be basically ORDNC. What do you mean by ORDNC? ORDNC means order of RD not complied. Order of regional director not complied. ORDNC, order of regional director not complied. So central, if I don't comply with the order of central government, then central government will itself change the name of the company, and ROC will change the name of the company and issue fresh certificate of incorporation, and this fresh certificate of incorporation will be in the form number INC 11C, and wherever the name of the company is printed, they have to add this words order of RD not complied. Everywhere, whenever the name of the company is displayed, they have to display this word also, order of RD not complied, along with the name. So this is the simple concept of rectification of name. I hope this point is crystal clear to all of you. So this is the simple concept of rectification of name. So we are done with this alteration of name clause. This boring paragraphs, we are done with this through the charts. So we are done with this alteration of name clause and this procedure. We are done with this procedure. Just study from the book what are the documents, attachments you need to attach along with the run. A copy of board resolution, like approval of trademark, approval, central government approval if required, IRDA approval, authority approval if required. So just see the attachment. After that, we are done with this, we are done with all this, we are done with this. So now the small topic is effect of name change. There's a small topic, effect of name change. So what is the effect of name change? Is the effect such that the old company is dissolved and new company established? No sir, no. Still the old company is continuing. Because of the change of name, it's not like the old company is dead and new company came into existence. If Amitabh Bachchan change its name to, let's say, change its name to Thanos, it's not like Amitabh Bachchan is died and a new person has born. No, he just changed his name. It doesn't mean that he's died. So, what is the effect of change of name? Number one, company is not dissolved, sir. No new company is coming into existence. Still old company is continuing. But sometimes there are the court cases running, court cases pending in the old name. So, if any old, there is already court case which is pending, which is running in the old name of the company, that can continue in the old name, or you can shift it to the new name. So if there is any old legal proceeding, that may continue with the old name or even with the new name, no issue. You can continue it with the old name, or you can change it to the new name and you can now continue further in the new name. So with respect to old legal proceedings which are running from past, so they can continue in old name also, no issue. But now onwards, after the name is changed, if now onwards if you will start any new legal proceeding, then you must start with the new name. Now you cannot start with the old name. So this is the simple effect of change of name, and we are done with the alteration of name clause of the company very properly. Give me a big fat thumbs up in the chat box if you are done with this whole process of alteration of name clause of the company, effect of name change, and this rectification of name. These 3 points. Great, everybody is crystal clear. And you know what? Now we'll do the alteration of registered office clause, and you might find one question. You might find one question from this topic. Might. It's like it might come. I am assuming it. There must be one question from the alteration of registered office clause in your paper. And this chapter, alteration of MOA, is very important. Okay, great. Great. So now we'll do with the alteration of registered office clause. No, Tushar, if there is any old proceeding, it may continue in the old name also, and it's your wish if you want to shift it to the new name. So you have got option. You can either continue it in the old name, or you can continue it with the new name. So in the old legal proceeding, you have that option. Is your doubt clear, Tushar? Now the next topic is alteration of registered office clause, which is given in section 12 and section 13. Shifting of registered office clause can be done in four ways. Number one, shifting within the local limits of same CTV. CTV means city, town or village. So you can either shift your registered office within the same city, town or village. Let's take an example of, we are shifting the registered office of Yashas Academy from first floor to sixth floor. Same city. Now, another example, we are shifting the registered office of the company from one city to another, but within the same state. Example, we are shifting our Yashas Academy registered office from Jayanagar to Vijayanagar. That is one city to another, but within same state. And third is one city to another within the same state, but change in jurisdiction of ROD. This can be possible only in two states, Maharashtra and Tamil Nadu, because only in case of Maharashtra and Tamil Nadu there are two ROC. In Maharashtra, one ROC is in Mumbai and one ROC is in Pune. In Tamil Nadu, one ROC is in Chennai, another is in Coimbatore. So only in these two states it might happen that you are changing the registered office from one city to another within the same state, but there is change in jurisdiction of RD. Example, you are shifting your registered office from Pune to Mumbai. And lastly, you are shifting your registered office from one state to another, from Karnataka to Chhattisgarh. So it's like one state to another. We'll do all this properly. But when I talk about alteration of MOA, so this is not the alteration of MOA. Only the last one is the alteration of MOA. Why, madam? Because remember, in MOA, we only mention the name of the state and not the full address. So if we are mentioning the name of the state, that the company is situated in the state of Karnataka. In the state of Karnataka. So in this, I don't have to change the name of the state. Only in this, I have to change the name of the state. So only in this fourth situation there will be alteration of MOA, but in this three situation there will not be alteration of MOA. These three situations are discussed in section 12, which is the section of registered office, and only this fourth one is discussed in section 13, which is the section of alteration of MOA. Now regarding the approvals, what approval are required? You are changing registered office within the local limit of same city, town or village. Just BR is sufficient. We want to shift our YSS Academy registered office from first floor to 10th floor, or let's say we just want to shift to the neighbor house. So within local limit now, we don't need to go to shareholder, just BR is enough. And whenever there is a change in registered office, we have to just get that address verified with the ROC. We have to get that address, that registered office verified with the ROC by filing a form which is INC 22 within 30 days. So you have to file INC 22 within 30 days. Done, madam, done. Now if I want to change my registered office from one city to another, Jayanagar to Vijayanagar, but in the same state, in the same Karnataka. So what I have to do? I am shifting my registered office from one city to another, Jayanagar to Vijayanagar. So I have to take shareholders approval also. So what I have to do? I have to pass board resolution. I have to pass special resolution, and whenever there is a special resolution, Fevicol, you have to file MGT 14 within 30 days, and you have to file INC 22 for the verification within 30 days to the ROC. So here we are done with this second situation. You don't need central government approval. You don't need RD approval. So is this alteration of memorandum? No, no, no. Third situation, you are shifting your registered office from one city to another within the same state, but change in jurisdiction of ROC. Example, you are changing your registered office from Mumbai to Pune. So, what approval is required here? You need to pass BR? Yes. You need to pass SR? Yes. And whenever there is a SR, there is MGT 14 Fevicol. Apart from this, in this situation, you also have to take approval of RD. Why? Because ROC jurisdiction is changing now. At first you are under ROC of Mumbai. Now you are under ROC of Pune. So there is a change in jurisdiction of ROC. So you have to take RD approval also in this case. So you have to take RD approval, and whenever there is a change in registered office, you have to verify that address by filing a form INC 22 to ROC within 30 days. So I hope you are clear with this three approval requirements. Last case, shifting of registered office from one state to another. Bro, this is alteration of memorandum. This fourth situation is the alteration of memorandum. Is this, if I talk alteration of memorandum, these three situations are not considered as the alteration of memorandum, but this last one is yes, the alteration of memorandum. Why? Because in this last one, the name of the state is changing. So finally, we have to delete the name Karnataka from the MOA and add the word Chhattisgarh if we are shifting the registered office from Karnataka to Chhattisgarh, one state to another. What approval is required? BR? Yes. SR? Yes. MGT 14? Yes. Also, you have to take central government approval. Central government has delegated its power to RD. So basically you have to take RD approval. It is yes, alteration of memorandum, and also you have to file INC 22 for the verification. This chart is very important. It must be crystal clear to all of you about approval requirement about alteration or shifting of registered office clause. Now you know what is the procedure of taking RD approval in this third case, and what is the procedure of taking central government or RD approval in this fourth case is discussed in very detail in your book. We have made a chart to understand the procedure of taking RD approval. So in the third case, what is the procedure of taking RD approval is discussed here, and in the fourth case, what is the procedure of taking RD approval is discussed here. So we will discuss this approval with this chart. It will be very easy for you. If you read this from the book, you will be find khichdi in your mind. There will be like a khichdi cooking in your mind. But if you will read this from this chart, this process will be crystal clear to all of you. So how you have to make application to the RD for taking approval for shifting registered office from one city to another within the same state where there is a change in jurisdiction of RD, which is basically case 3. So here you have to file application to RD. This is what? This is company, this is RD. So you have to file application to RD in the form number INC 23. And whenever you file application, certain documents you have to attach. Like first you must have passed BR, you must have passed SR. And whenever there is a SR, there is MGT 14. So you have to pass BR, then you have to pass SR. And then you have to file application in the form number INC 23. Along with that application, you have to attach as a proof a copy of BR, copy of SR, a declaration by the KMP or 2 director that company has not defaulted in any workman dues, because you should not have defaulted in any employee's dues, any employee salary. Otherwise, if you will flee to any other city, how will your employees recover that money? So you have to give a declaration that you have not defaulted in any employees dues and you have not defaulted in the creditors payment, that the company has obtained the consent of creditor or made provision for that payment, either made payment or obtained the consent. Okay, and they have to make an acknowledgement that the employee's interest is not adverse by the shifting of the registered office. So we'll give this application and these documents to RD. Now RD will check if everything is okay, either it will approve or reject. It will pass the order approving or rejecting within 15 days of the application, and then company will receive the order. Company has to file a copy of that order to ROC in the form number INC 28 within 30 days of the order. So company has to file a copy of order of RD in the form number INC 28 within 30 days of the order. And what ROC will do, if the shifting is approved, then ROC will certify within 30 days and will issue a certificate, new certificate to that effect, which will be conclusive evidence of the change of registered office, and the change will be effective from the date of that certificate. So this is the whole process of taking the RD approval in case 3. This is the whole procedure of taking RD approval in this case 3. I hope this point is crystal clear to all of you. This is very important. Trust me, this is made very easy. If you look at the book now, you'll go crazy. You'll go crazy. It is 3-pager procedure. 3-pager procedure. So you have to do selective study, smart study, read the book for the language, and revise from this chart. Okay. So I hope this procedure is crystal clear to you, that how you can take the RD approval. Case number 4. Case number 4 talks about shifting of registered office from one state to another. Case number 4 talks about shifting of registered office from one state to another. So here also you have to take RD approval. Yes, madam, we have to take RD approval. See here, this is the 4th case. In the 4th case, when you want to shift your registered office from one state to another, then also you have to take RD approval. And how can you take this RD approval? So this is the process given here, and this process a bit more lengthy. So please have patience. We'll cover it in next 5 to 10 minutes. The whole process of taking approval from RD. In my regular class, I took 1 hour, approx half an hour, not 1 hour, half an hour you can say, to explain these two procedures. But we'll try to cover this in 10 minutes. Okay. So what is the procedure of taking RD approval in this case number 4? So as you all know, first we have to pass BR/SR. Yes, that is so in all the cases. So first we have to pass BR, then we have to pass SR. Whenever there is SR, there is Fevicol MGT14. So this is like in all the cases. This is not an issue. The main additional requirement is, whenever you want to shift your registered office from one state to another, it's a big deal, bro. You are shifting your state. It's not easy. You have to make public announcement. You have to inform to the public that public, I am shifting my registered office from one state to another. Does anybody have any objection? Then come and say if you have any objection. So here you have to make public announcement at least 30 days before making application to to central government. So at least 30 days before making application to central government, you have to make public advertisement. So here at least 30 days before making application, you have to make public advertisement in form INC 26, and that public advertisement you have to make in newspapers, one in English, one in vernacular, in having circulation in the state where the registered office of the company is situated. And there are some people who require special attention. We want separate special notice. So the company has to give a special notice. They are saying we don't read newspaper. You have to give a separate notice to our address. So the company has to give a separate notice to these people who creditors, debenture holders, ROC, SEBI, or any other regulatory body. So basically, here when the registered office is shifted from one state to another, the main concern is company is not defrauding creditors now. It's not like the if the company want to shift its registered office from Karnataka to Chhattisgarh, it might be possible that the company has taken so much of loan from Karnataka people and in order to escape the liability, they are running away from Karnataka, they are running to Chhattisgarh. So it might be possible now that the company is defrauding its creditor. So that is why here there is a major role of creditors and debenture holder. If they have any objection now, then central government will not approve your shifting of registered office. So here there is another point. Now you made a public advertisement. You made a public advertisement. If anybody has any objection, you can submit your objection. Now finally, the company will make application in the form number INC 23. This is same to central government, basically power delegated to RD. And along with this form, you have to give certain attachments. Certain attachments like very easy, copy of BR, copy of SR, minutes of general meeting, copy of MOA, AOA, list of creditors and debenture holder. Here you also have to give a list of your creditors and debenture holder. And you have to give a declaration. There must be a declaration of a CS and two director that yes, the list of creditor or debenture holder is correct. The value of debts are proper estimates, that the value of debts which they are given, okay, we owe 1 crore to Mr. A, 2 crore to Mr. B, that value we have given correct and proper estimate. We have not given you false information, and we have to give a declaration that no employee will be retrenched. Just by virtue of shifting your registered office from one state to another, you cannot retrench any employee. You cannot say that now we don't need employee. You cannot remove any employee. So employees' interest should also be protected. Basically, all this information you have to attach along with the your INC 23. Also, you have to submit this to the Chief Secretary of the state. You have to give an acknowledgement that you have submitted a copy of this declaration to the Chief Secretary of the state. So, you will submit application to central government power delegated to RD, and now central government will make inquiry and raise objection from people. These people might give objection. So now there must be two situations, if any objection is received or if any no objection is received. So in case no objection is received, so it will be done faster. So in case no objection is received, then central government might approve or reject. Central government will think it is okay, then it will approve. If central government, if in the opinion of central government it is not good, then it will reject. It will pass order approving or rejecting within 15 days of the application. But if any objection is received, let's say if creditor have raised objection, if any person has raised any objection, then central government will take time to hold the hearings and all. So at that point of time, central government will pass order approving or rejecting. It might approve or reject within 60 days of the application. Just a minute. Okay. So uh, there might be two situations, that any objection is received or any objection is not received. If no objection is received, order will be passed within 15 days. If objection is received, order will be passed within 60 days. And whenever an order is received, you have to file a copy of order of RD to the ROC within 30 days in the form number INC 28. And if the central government or RD has approved the alteration of a registered office from one state to another, in that case you have to file INC 22 to the ROC. INC 22 is for the verification of the change in registered office, and this you will submit to the ROC of the state where the registered office is going to be shifted. Like if the registered office is shifting from Bangalore to Chhattisgarh, then you have to submit this to the ROC of Chhattisgarh. And then what ROC will do? ROC will certify and issue the fresh certificate of incorporation. Why fresh? Because whenever there is alteration of MOA, then ROC issues new fresh certificate of incorporation. So in this situation, when the registered office is shifted from one state to another, there is alteration of MOA. That is why the ROC issues new and fresh certificate of incorporation within 30 days. So this is the whole process of shifting of registered office from one state to another. How do you take permission of the RD for shifting your registered office from one state to another. I hope this procedure is crystal clear to all of you, and we are done with the alteration of registered office clause. Congratulations. See here in the book you will find this topic, alteration of registered office within the local limits, outside the local limits. This case number 3. We are done with all this long provisions of the book. This procedure to be followed. We are done with this. We are done with this. So finally we are done with all these procedures of shifting of registered office from one state to another and all that 4 cases. Give me a quick fat thumbs up in the chat box if you are crystal clear till here. Great. So now we can start with our there's a small topic, that can a one state refuse or object to the shifting of registered office just because of the loss of revenue. If let's say the company will shift from Chhattisgarh to Karnataka, so can the Chhattisgarh state government object that no, we won't allow the shifting of this company, because if this company will shift from Chhattisgarh to Karnataka, there will be loss of revenue of Chhattisgarh government. So can a state government say that? The answer is no. State government don't have right to object the shifting of registered office just because of the reason that the state government will lose its revenue, because we will not look for the interest of one state. We will look as the interest of whole country, that even if the Chhattisgarh government is losing some revenue, Karnataka government's revenue will increase now. So ultimately the overall India will not be affected. So we will look this from country's perspective and not the state perspective. So the state cannot object to the transfer, to the shifting, just because of the reason that the state government will lose its revenue. Okay, next is, can employees raise their voice? Can employees object against the shifting? Yes, employees can also object against the shifting if their interest is prejudicially affected. So employee can form union, trade union, and the employees union or the trade union also, they are the legal body, so they can sue the company. They can sue the company against the shifting of registered office from one state to another. But there is one exception, that they cannot oppose or they cannot object just because of the ground of loss of revenue or unemployment. Loss of revenue or unemployment. Why? Because they are also being offered job in another state now. So Chhattisgarh employees cannot say that okay, we will be unemployed. Why? You come to Karnataka, you are being given job in Karnataka, right? So वैसे तो employees can take action, they can sue, but they cannot sue because of this reason that there will be loss of revenue or unemployment. I hope this point is crystal clear to all of you. The next alteration is alteration of object clause. The next alteration is alteration of object clause. And about this is a small, you know what, we are done with mountain, we are done with mountain, we are done with alteration of name clause, alteration of registered clause. This chapter is done. Now laddu, now it's laddu. Only small procedure are left. We are done with mountain, bro. Now just small procedure are left about the alteration of object clause, alteration of liability clause, and alteration of capital clause. So we'll be done in just next 10 to 15 minutes. Alteration of object clause. Can a company alter its object? Yes, at first, yeah, let's say I formed a company, Edu-Mention Private Limited, and I included in the object doing education business. Now I want to also do the business of, let's say, hotel business. So can I alter my object and include this power also? Yes, I can. Yes, I can. So I can alter my object and include this power of doing hotel business also, power of doing restaurant business also, food business also. So I can alter my object. I can add, I can delete, I can change any object. Yes. So object clause can be changed. But by doing what? Here we don't need government approval. Here we don't need government approval, we just have to pass SR. We just have to pass SR. So this is the company, it want to alter the object clause. What we have to do, simply we have to pass SR. And whenever there is a SR, Fevicol MGT 14 within 30 days to ROC. So company has to file MGT 14 within 30 days to ROC, and along with MGT 14 you have to give some proof like copy of SR, notice of general meeting, the changed MOA, the altered MOA, and then ROC will check everything. Is everything is okay? ROC will certify the change, and within 30 days, an alteration will be effective from the date of registration. ROC will register the change and the alteration will be effective from the date when the ROC registered it. So this is the small concept of alteration of object clause. I hope this is crystal clear to all of you. So with this we are done with alteration of object clause, which is also given in section 13. Very small procedure, just SR is required plus MGT 14. SR plus MGT 14. There is a small concept of change in object of prospectus. This concept is also there in the company's law, that whenever you issue prospectus, you mention the object, that you are issuing prospectus for raising public money. So you have to give the object that आप इतनी धनराशि का क्या करेंगे? What will you do with that money? What will you do with that money? So whatever money you will raise through public offer, you will utilize that money for which purpose? So you have to specify the object. And if you want to change that object which is mentioned in prospectus, then also you have to pass special resolution. But here there is one additional requirement, that you have to give public announcement, because prospectus is a public document. Now you want to change the object of the prospectus, so you have to make the public announcement and you have to publish in the newspaper, one in English, one in vernacular, plus website. And by making announcement, you have to give exit opportunity, that we are changing the object. If any shareholder want to exit from the company, they can exit. So we should give exit opportunity to the dissenting shareholders. And basically the promoters of the company have to give exit opportunity, that if you want to exit, okay, you can sell your shares to us and you can exit from the company. So whenever company wants to change the object mentioned in the prospectus, then SR is to required. Additionally, we have to make public announcement and we have to give exit opportunity to the existing shareholders of the company. The next alteration is alteration of liability clause. Very easy. Usually the liability clause cannot be altered, but if you are changing the company from one type to another, we studied now there can be three types of company: company limited by shares, company limited by guarantee, or unlimited company. So if you are changing a company limited by shares to company limited by guarantee, or let's say you are changing the company to company limited by shares to unlimited, or you are changing unlimited company to limited company, then liability clause will automatically get entered. So in order to alter the liability clause, you have to change the whole company, you have to convert the whole company. And you know what is the process of conversion? What is the process of conversion of one type of company into another type of company? That is given in section 18, which we will study in next chapter. So in order to alter your liability clause, normally it cannot be done, but there is one way. In order to alter your liability clause, you have to convert the company, one type of company into another type of company, limited company into unlimited, or unlimited company into limited company. So for that you have to follow the procedure mentioned in section 18. Section 18 mentioned the procedure for conversion of one type of company into another type of company. So what is the process of alteration of liability clause? Simply you have to pass special resolution, and whenever there is special resolution, Fevicol MGT 14 within 30 days, and also you have to follow the procedure of section 18 for the conversion of one type of company into another type of company. I hope this point is crystal clear to all of you with respect to alteration of liability clause. We are done with this, and the last clause which can be altered is capital clause. This same concept is there in the company law as well. This is a same topic. There are some topics overlapping. Overlapping. The same topic is in both subjects, is in SBEC also and in company law also. Alteration of capital clause, which is basically given in section 61 of the Companies Act. And to alter any other clause, you need to pass SR. Like for this also you need to pass SR. For this also you need to pass SR. For shifting of registered office from one state to another, you have to pass SR. For changing the name clause also you have to pass SR. So for changing any clause of the MOA, you have to pass SR. But in order to change the capital clause, you don't need SR. OR is sufficient. Capital clause is the only clause of the MOA which can be altered by OR. In order to alter any other clause, you have to pass special resolution, and this alteration of share capital is not given in section 13, it is given in section 61. So what are the conditions for affecting alteration of share capital? It must be AOA authorized, there must be authorization in the AOA. Next, it must be OR authorized, you have to pass ordinary resolution, and whenever there is a change in the capital clause, you have to file a form to the ROC, that is form number SH7, within 30 days. So whenever there is alteration of the share capital clause, you have to file SH7 to ROC within 30 days. Capital clause can be altered in 5 ways. Number 1, increase in authorized capital. You want to increase the limit, increase in authorized capital. Number 2, consolidation or subdivision. Consolidation means to um, add two shares and make one share. Let's say there is one share of 5 rupees and one share of 5 rupees, and you are adding these two shares and making one share. It's like you are attaching these two shares. So now you are making one big share of 10 rupees. So this is like consolidation into larger denomination, means larger value. You are consolidating two shares into one share of larger value. This consolidation is also alteration of capital clause. Subdivision. Subdivision is just opposite. Just opposite. Let's say you have one big share of 10 rupees and you are dividing it into two smaller pieces. Like you have one big share of 10 rupees and you are dividing it into two smaller share, like one share of 5 rupees and one share of 5 rupees. So it is like subdivision. Subdivision means dividing your shares into smaller denomination. This is also alteration of share capital. Next is conversion of shares into stock and vice versa. Stock is nothing but the bundle of shares. So if you are converting shares into stock or stock into shares, that is also alteration of share capital. Lastly, cancellation of shares not taken up by the public, diminution of share capital. So let's say I issued 500 lakh shares. I offered 500 lakh shares to public, but the public didn't subscribe. Public subscribed only 100 lakh shares, 400 lakh shares, not 100 lakh. Let's say public didn't subscribe to this, so this remained unsubscribed. So in that case I have to reduce this. So what I will do, I will reduce this issued capital by the amount which is not actually purchased by the public, which is not actually subscribed by the public. This is known as cancellation of share capital. Cancellation of share which is not purchased by the public, cancellation of share which is not taken up by the public, and this is also known as diminution of share capital. This cancellation of share capital is also known as diminution of share capital, and all these 5 cases are the cases of alteration of share capital. In all the cases, share capital will be altered and you have to pass OR, ordinary resolution, and file SH7 to ROC within 30 days. Within 30 days. There is one small point, that if due to consolidation there is change in voting percentage, then you have to take NCLT approval. With this we are done with the alteration of capital clause. However, one last clause, which is subscription clause. Subscription clause cannot be altered. As I already told you, you cannot change your parent, you cannot alter your parent. So subscription clause cannot be altered. So we are done with the alteration of MOA. We are done with the alteration of MOA. So we studied how to alter the name clause, how to alter the registered office clause, how to alter the object clause, how to alter liability and capital clause. Okay, and however association clause cannot be altered. So we are done with this alteration of MOA, which is like a mountain topic. We are finally done with a good topic, important topic, and a mountain topic, large topic. So congratulations. And a last small topic is left, alteration of AOA. So we are done with this alteration of object clause. We are done with this alteration of liability clause, alteration of capital clause. Lastly, there is one topic, which is alteration of article. How you can, this is very laddu, everybody of you must know that section 13 talks about alteration of MOA and section 14 talks about alteration of AOA. How you can alter your AOA? Simply by passing SR. Simply by passing SR. It's very easy. So you have to do nothing. Just pass SR. Just pass SR in order to alter your AOA. And whenever there is a SR, Fevicol MGT14 within 30 days. So whenever you pass SR, you have to file MGT14 within 30 days to the ROC. Along with a copy of SR, you have to give altered AOA to the ROC. So you have to give MGT14 and along with that you have to give a copy of SR and altered AOA to the ROC. So this is the small procedure that in order to alter AOA, you simply have to pass special resolution and submit MGT14. However, if you are converting a private company into public company or a public company into private company, because of that conversion, if you are changing the article, then along with MGT14, one additional form you have to file to the ROC, that is INC 27 within 15 days. But this INC 27 is required only in case of conversion of private company to public company or vice versa. Vice versa means public to private, private to public or public to private. So simply I want to alter my article, pass SR, Fevicol MGT14, that's it. But if you are altering article because of the conversion of public to private or private to public, then you have to submit one more additional form, that is INC 27 within 15 days. So we are done with this chapter. We are done with this huge chapter, alteration of Moa and Aoa. I remember I took 2 to 3 classes in regular batch to complete this whole chapter of Moa and Aoa. So how was the revision? How was the revision? Trust me, this chapter, this short notes of this chapter is, you will in one day before exam, when you will revise through this, you will feel the advantage of this revision and you will feel the advantage of this short notes. It's my promise. Okay, so I really hope that whosoever is attending this revision and whosoever are referring these notes, it will be beneficial for you all and you will do great in your exams. Alteration of AOA, we are done with alteration of AOA. Thank you, Pings. One small point, one small point, that you can alter the AOA. It is the inherent power of the company that company can alter the AOA by passing special resolution. Nobody can say to a company that company cannot alter AOA. Company can alter AOA. It's the inherent power of the company that company can alter AOA by passing special resolution. But there are certain exceptions. This is a separate topic, that there are certain limitations to the alteration power. There are certain limitations that while altering the AOA, company should take care of the few things. Like while altering AOA, company should take care that it is not exceeding the power given in memorandum. Even if you're altering the AOA, it's okay, but it should be within the boundaries of memorandum. It should not go beyond the powers of memorandum. Number one. Number two, you cannot alter in such a way that it become inconsistent with the Companies Act. You can alter your AOA, but it should be within the powers of Companies Act. Number three, you cannot put anything illegal, like you cannot alter the AOA and write we will murder this person. So you cannot include anything illegal or opposed to public policy, and your alteration should be in the best interest of company. It should be bona fide and for the benefit of the company. And you cannot alter AOA to fraud minority, to fraud any person. So you cannot alter your AOA to do fraud or to wrongful activity, to do fraud with any minority or any person. Okay, so these are certain exceptions that while altering, although the company has full freedom to alter the AOA, but there are certain conditions which company have to take care of while altering the AOA. Company cannot alter the article to expel member. Like company cannot include any provision in the article to expel any member. I don't like you, please, I want to expel you from the company. No. Member has a right. Member has a right. A company cannot expel, can never expel a member by including a clause in the article. So company cannot include a clause in the article. Company cannot alter the article in such a way to expel any existing member. And company cannot alter the article to escape from any obligation. Like company cannot write article, company will never be held liable. So to escape from any liability, you cannot alter article, and you cannot alter article with retrospective effect. It will have already always prospective effect. Like if you alter article today, so it will take effect from today onwards and future. It will not have past effect. You cannot change past activities. So it will not have retrospective effect. It will have prospective effect. From now onwards, that alteration will be applicable. So this is the small point. This is the small point. And you know what? You cannot write a word in the article that article can never be altered. You cannot write anything. You cannot, like if I wrote in my article that this clause can never be altered, can I write that? The answer is no. The answer is no. Article is always alterable, although you can put the entrenchment provision, but you can never put anything like this article is never alterable. You cannot put that clause. Okay. We are done with this alteration of article. What is the effect of altered article? This altered article is also binding on the company and the members in the same manner as the original article was binding. So similarly, this altered article will also be binding on the member in the same way like the original article. So this is the small concept of alteration effect of altered article. And whenever there is an alteration in the MOA and AOA, whenever there is alteration in MOA AOA, you have to note that in every copy of MOA AOA, number of copies, how many Xerox copies are there of MOA AOA, you have to note the alteration in all the copies of MOA AOA. So with this we are done with this. We are finally done with this chapter, your alteration of MOA and AOA. We are done with the alteration of your MOA and AOA. We could have started with the next chapter if had we started at 12, but no worries, today's class was just short. In this short we revised the very important concept, very important chapter. We completed MOA, alteration of MOA. Tomorrow we will study the conversion of one company into another, conversion chapter, and we'll do LLP chapter. So tomorrow we'll do two chapters, that is conversion and LLP. Conversion and LLP. We will do two chapters, conversion and LLP. Okay. If anybody has any doubt, please do let me know over Telegram. I'll surely try to clear your doubts. So I'll see you in the revision of company law, and tomorrow again in the revision of SBEC.